suffrage, political franchise, or simply franchise. Distinct from other rights to vote. Is the right to vote gained through the democratic process. The right to run for office is sometimes called candidate eligibility, and the combination of both rights is sometimes called full suffrage. In many languages, the right to vote is called the active right to vote and the right to run for office is called the passive right to vote. In English, these are sometimes called active suffrage and passive suffrage. Suffrage is often conceived in terms of elections for representatives. However, suffrage applies equally to initiatives and referenda. Suffrage describes not only the legal right to vote, but also the practical question of whether a question will be put to a vote. The utility of suffrage is reduced when important questions are decided unilaterally by elected or non-elected representatives. In most democracies, eligible voters can vote in elections of representatives. Voting on issues by initiative may be available in some jurisdictions but not others. For example, while some U.S. states such as California and Washington have exercised their shared sovereignty to offer citizens the opportunity to write, propose, and vote on referendums and initiatives, other states have not. Meanwhile, the United States federal government does not offer any initiatives at all. On the other hand, many countries, such as Switzerland, permit initiatives at all levels of government. Suffrage is granted to qualifying citizens once they have reached the voting age. What constitutes a qualifying citizen depends on the government's decision, but most democracies no longer extend different rights to vote on the basis of sex or race. Resident aliens can vote in some countries, and other countries make exceptions for citizens of countries they have close links to. Etymology: the word suffrage comes from Latin suffragium, meaning vote, political support, and the right to vote. The etymology of the Latin word is uncertain, with some sources citing Latin suffragare lend support, vote for someone, from sub under plus frigga crash, din, shouts, related to fringe to break. Other sources say that attempts to connect suffragium with frigga cannot be taken seriously. Some etymologists think that it may be related to suffrago and may have originally meant an ankle bone or knuckle bone. Types of suffrage: universal suffrage. Where universal suffrage exists, the right to vote is not restricted by sex, race, social status, or wealth. It typically does not extend a right to vote to all residents of a region. Distinctions are frequently made in regard to citizenship, age, and occasionally mental capacity or criminal convictions. The short-lived Corsican Republic was the first country to grant limited universal suffrage for all inhabitants over the age of 25. This was followed by other experiments in the Paris Commune of 1871 and the island Republic of Franceville. In 1893, New Zealand became the first major nation to achieve universal suffrage, and the Freedom in the World Index lists New Zealand as the only free country in the world in 1893. In 1906, Finland became the second country in the world, and the first in Europe, to grant universal suffrage to its citizens. Women's suffrage. Women's suffrage is the right of women to vote on the same terms as men. This was the goal of the suffragists and the suffragettes. Limited voting rights were gained by some women in Sweden, Britain, and some western U.S. states in the 1860s. In 1893, the British colony of New Zealand became the first self-governing nation to extend the right to vote to all adult women. In 1894 the women of South Australia achieved the right to both vote and stand for parliament. The autonomous Grand Duchy of Finland in the Russian Empire was the first European nation to allow all women to both vote and run for parliament. Equal suffrage. Equal suffrage is sometimes confused with universal suffrage, although its meaning is the removal of graded votes, where a voter could possess a number of votes in accordance with income, wealth or social status. Censor suffrage, also known as censitary suffrage, the opposite of equal suffrage, meaning that the votes cast by those eligible to vote are not equal, but are weighed differently according to the person's rank in the census. Suffrage may therefore be limited, usually to the propertied classes, but can still be universal, including, for instance, women or ethnic minorities, if they meet the census. Compulsory suffrage. Where compulsory suffrage exists, those who are eligible to vote are required by law to do so. 32 countries currently practice this form of suffrage. Forms of exclusion from suffrage: religion. In the aftermath of the Reformation, it was common in European countries for people of disfavored religious denominations to be denied civil and political rights, often including the right to vote, to stand for election or to sit in Parliament. In the Great Britain and Ireland, Roman Catholics were denied the right to vote from 1728 to 1793, and the right to sit in Parliament until 1829. The anti-Catholic policy was justified on the grounds that the loyalty of Catholics supposedly lay with the Pope rather than the national monarch. In England and Ireland, several acts practically disenfranchised non-Anglicans or non-Protestants by imposing an oath before admission to vote or to run for office. The 1672 and 1678 Test Acts forbade non-Anglicans to hold public offices. The 1727 Disenfranchising Act took away Catholics' voting rights in Ireland, which were restored only in 1788. Jews could not even be naturalized. An attempt was made to change this situation, but the Jewish Naturalization Act 1753 provoked such reactions that it was repealed the next year. Nonconformists were only allowed to run for elections to the British House of Commons in 1828, Catholics in 1829, and Jews in 1858. Benjamin Disraeli could only begin his political career in 1837 because he had been converted to Anglicanism at the age of 12. In several states in the U.S. after the Declaration of Independence, Jews, Quakers or Catholics were denied voting rights and/or forbidden to run for office. The Delaware Constitution of 1776 stated that every person who shall be chosen a member of either house, or appointed to any office or place of trust, before taking his seat, or entering upon the execution of his office, shall also make and subscribe the following declaration, to wit, I, A.B. do profess faith in God the Father, and in Jesus Christ his only Son, and in the Holy Ghost, one God, blessed forevermore. And I do acknowledge the Holy Scriptures of the Old and New Testament to be given by divine inspiration. This was repealed by Article I, Section 2 of the 1792 Constitution. No religious test shall be required as a qualification to any office, or public trust, under this state. The 1778 Constitution of the State of South Carolina stated that no person shall be eligible to sit in the House of Representatives unless he be of the Protestant religion. The 1777 Constitution of the State of Georgia that the representatives shall be chosen out of the residents in each county and they shall be of the Protestant religion. In Maryland, voting rights and eligibility were extended to Jews in 1828. In Canada, several religious groups were disenfranchised by the Wartime Elections Act of 1917, mainly because they opposed military service. This disenfranchisement ended with the end of the First World War, but was renewed for do-overs from 1934 to 1955. The first constitution of modern Romania in 1866 provided in Article 7 that only Christians could become Romanian citizens. Jews native to Romania were declared stateless persons. In 1879, under pressure of the Berlin Peace Conference, this article was amended granting non-Christians the right to become Romanian citizens, but naturalization was granted on a case-by-case basis and was subject to parliamentary approval. An application took over 10 years to process. Only in 1923 was a new constitution adopted, whose Article 133 extended Romanian citizenship to all Jewish residents and equality of rights to all Romanian citizens. In the Republic of Maldives, only Muslim citizens have voting rights and are eligible for parliamentary elections. On November 25, 2011, the UN Human Rights Chief called on Maldivian authorities to remove the discriminatory constitutional provision that requires that every citizen be a Muslim. Wealth, tax class, social class. Until the 19th century, many Western democracies has property qualifications in their electoral laws. For example, only landowners could vote, or the voting rights were weighed according to the amount of taxes paid. Most countries abolished the property qualification for national elections in the late 19th century, but retained it for local government elections for several decades. Today these laws have largely been abolished, although the homeless may not be able to register because they lack regular addresses. In the United Kingdom, until the House of Lords Act 1999, peers who were members of the House of Lords were excluded from voting for the House of Commons because they were not commoners. In Britain and some other monarchies, the sovereign is ineligible to vote in parliamentary elections. Knowledge. Sometimes the right to vote has been limited to people who had achieved a certain level of education or passed a certain test, for example literacy tests in some states of the U.S. Race. Various countries, usually countries with the dominant race within a wider population, have historically denied the vote to people of particular races, or to all but the dominant race. This has been achieved in a number of ways: official, laws and regulations passed specifically disenfranchising people of particular races. Indirect, nothing in law specifically prevents anyone from voting on account of their race, but other laws or regulations are used to exclude people of a particular race. In southern states of the United States of America before the passage of the Civil Rights Act of 1964 and the Voting Rights Act of 1965, poll taxes, literacy and other tests were used to disenfranchise African Americans. Property qualifications have tended to disenfranchise a minority race, particularly if tribally owned land is not allowed to be taken into consideration. In some cases this was an unintended consequence. Unofficial, nothing in law prevents anyone from voting on account of their race, but people of particular races are intimidated or otherwise prevented from exercising this right. In New Zealand the Maori have been enfranchised effectively since 1865 at the conclusion of the Maori War. Maori still have the choice of voting in a general electorate or a solely Maori electorate. Age. All modern democracies require voters to meet age qualifications to vote. Worldwide voting ages are not consistent, differing between countries and even within countries, usually between 16 and 21 years. Early voting would extend voting rights to everyone including children regardless of age. Criminality. Many countries restrict the voting rights of convicted criminals. Some countries, and some U.S. states, also deny the right to vote to those convicted of serious crimes after they are released from prison. In some cases the denial of the right to vote is automatic on a felony conviction. In other cases deprivation of the vote is meted out separately, often limited to certain crimes such as those against the electoral system. In the Republic of Ireland, prisoners are allowed the right to vote, following the Hearst v UK ruling, and this was granted in 2006. Canada allowed only prisoners serving a term of less than 2 years the right to vote, but this was found unconstitutional in 2002 by the Supreme Court of Canada in Sauver Copyright v. Canada, and all prisoners were allowed to vote as of the 2004 Canadian federal election. Residency. Under certain electoral systems elections are held within national jurisdictions, preventing persons who would otherwise be eligible from voting because they do not reside within such a jurisdiction, or because they live in an area that cannot participate. In the United States, residents of Washington, D.C. receive no voting representation in Congress, although they have full representation in presidential elections. Residents of Puerto Rico have neither. Sometimes citizens become ineligible to vote because they are no longer resident in their country of citizenship. For example, Australian citizens who have been outside Australia more than 1 and less than 6 years may excuse themselves from the requirement to vote in Australian elections while they remain outside Australia. In some cases, a certain period of residence in a locality may be required for the right to vote in that location. For example, in the United Kingdom up to 2001, each February 15 a new electoral register came into effect, based on registration as of the previous October 10, with the effect of limiting voting to those resident 5 to 17 months earlier depending on the timing of the election. Nationality. In most countries, suffrage is limited to citizens and, in many cases, permanent residents of that country. However, some members of supranational organizations such as the Commonwealth of Nations and the European Union have given voting rights to citizens of all countries within that organization. Until the mid-20th century, many Commonwealth countries gave the vote to all British citizens in the country, regardless of whether they were normally resident there. In most cases this was because there was no distinction between British and local citizenship. Several countries qualified this with restrictions preventing non-white British citizens such as Indians and British Africans from voting. Under European Union law, citizens of European Union countries can vote in each other's local and European Parliament elections on the same basis as citizens of the country in question. Naturalization. In some countries, naturalized citizens do not have the right to vote or to be candidate either permanently or for a determined period. Article 5 of the 1831 Belgian Constitution made a difference between ordinary naturalization and grand naturalization. Only foreigners who had been granted grand naturalization were entitled to vote, be a candidate for parliamentary elections, or be appointed minister. However, ordinary naturalized citizens could vote for municipal elections. Ordinary naturalized citizens and citizens who had acquired Belgian nationality through marriage could vote, but not be candidates for parliamentary elections in 1976. The concepts of ordinary and grand naturalization were suppressed from the Constitution in 1991. In France, the 1889 nationality law barred those who had acquired the French nationality by naturalization or marriage from voting, eligibility and access to several public jobs. In 1938 the delay was reduced to 5 years. These discriminations, as well as others against naturalized citizens, were gradually abolished in 1973 and 1983. In Morocco, a former French protectorate, and in Guinea, a former French colony, naturalized citizens are prohibited from voting for 5 years after their naturalization. In the Federated States of Micronesia, citizens must be a Micronesian citizen for at least 15 years to run for parliament. In Nicaragua, Peru and the Philippines, only citizens by birth are eligible for being elected to the national legislature. Naturalized citizens enjoy only voting rights. In Uruguay, naturalized citizens have the right of eligibility to the parliament after 5 years. In the United States, the president and vice president must be natural-born citizens. All other governmental offices may be held by any citizen, although citizens may only run for Congress after an extended period of citizenship. Function. In France, an 1872 law, rescinded only by a 1945 decree, prohibited all army personnel from voting. In the United Kingdom, public servants have to resign before running for an election. The 1876 Constitution of Texas stated that the following classes of persons shall not be allowed to vote in this state, to wit, all soldiers, Marines and seamen, employed in the service of the Army or Navy of the United States. In many countries with a presidential system of government a person is forbidden to be a legislator and an official of the executive branch at the same time. Such provisions are found, for example, in Article I of the U.S. Constitution. History of suffrage around the world. Finland was the first nation in the world to give all adult citizens full suffrage, in other words the right to vote and to run for office. New Zealand was the first country in the world to grant all adult citizens the right to vote, but women did not get the right to run for the New Zealand legislature until 1919. Australia. 1884, Henrietta Dugdale forms the first Australian women a unregistered trademark suffrage society in Melbourne. 1894, South Australian women eligible to vote. 1899, Western Australian women eligible to vote. 1902, the Commonwealth Franchise Act enables women to vote federally, and in the state of New South Wales. 1921, Edith Cowan elected to the West Australian Legislative Assembly as member for West Perth, the first woman elected to any Australian Parliament. 1962, Aboriginal peoples guaranteed the right to vote in Commonwealth elections. Brazil. 1932, vote becomes obligatory to all adults over 21 years old. Until then, vote was not obligatory but only allowed to men and limited by income and occupation. 1955, adoption of standardized voting ballots and identification to mitigate frauds. 1964, military regime established. From then on, presidents were elected by members of the Congress, chosen by regular vote. 1989, re-establishment of universal suffrage for all citizens over 16 years old. People considered illiterate are not obliged to vote, as people over younger than 18 and older than 70 years old. People under the obligation rule shall file a document to justify their absence should they not vote. 2000, Brazil becomes the first country with full adoption of electronic ballots in their voting process. Canada, 1916, Manitoba becomes the first province where women have the right to vote in provincial elections. 1917, Wartime Elections Act, gives voting rights to women with relatives fighting overseas. Voting rights are stripped from all enemy aliens. Military Voters Act, gave the vote to all soldiers, even non-citizens, and to females serving as nurses or clerks for the armed forces, but the votes are not for specific candidates but simply for or against the government. 1918, women gain full voting rights in federal elections. 1919, women gain the right to run for federal office. 1940, Quebec becomes the last province where women's right to vote is recognized. See Canadian women during the World Wars for more information on Canadian suffrage. 1947, racial exclusions against Chinese and Indo-Canadians lifted. 1948, racial exclusions against Japanese Canadians lifted. 1955, religious exclusions are removed from election laws. 1960, right to vote is extended unconditionally to First Nations people. 1960, right to vote in advance is extended to all electors willing to swear they would be absent on election day. 1965, First Nations people granted the right to vote in Alberta provincial elections, starting with the Alberta general election. 1967, 1969, First Nations people granted the right to vote in Quebec provincial elections, starting with the Quebec general election. 1970, 1970, voting age lowered from 21 to 18. 1982, Canadian Charter of Rights and Freedoms guarantees all adult citizens the right to vote. 1988, Supreme Court of Canada rules mentally ill patients have the right to vote. 1993, any elector can vote in advance. 2000, legislation is introduced making it easier for people of no fixed address to vote. 2002, prisoners given the right to vote in the riding where they were convicted. All adult Canadians except the chief and deputy returning officers can now vote in Canada. Finland, 1906, full suffrage for all citizens adults aged 24 or older at beginning of voting year. 1921, suppression of property-based amount of votes on municipal level. Equal vote for everybody. 1944, voting age lowered to 21 years. 1969, voting age lowered to 20 years. 1972, voting age lowered to 18 years. 1981, voting and eligibility rights were granted to Nordic Passport Union country citizens without residence condition for municipal elections. 1991, voting and eligibility rights were granted to, extended to all foreign residents in 1991 with a 2 years residence condition for municipal elections. 1995, residence requirement abolished for EU residents, in conformity with the European legislation. 1996, voting age lowered to 18 years at date of voting. 2000, Section 14, Al. 2 of the 2000 Constitution of Finland states that every Finnish citizen and every foreigner permanently resident in Finland, having attained 18 years of age, has the right to vote in municipal elections and municipal referendums, as provided by an act. Provisions on the right to otherwise participate in municipal government are laid down by an act. Hong Kong, minimum age to vote was reduced from 21 to 18 years in 1995. According to the Basic Law, the Constitution of the Territory since 1997, stipulates that all permanent residents have the right to vote. The right of permanent residents who have right of abode in other countries to stand in election is, however, restricted to 12 functional constituencies by the Legislative Council Ordinance of 1997. The right to vote and the right to stand in elections are not equal. Less than 250,000 of the electorate are eligible to run in the 30 functional constituencies, of which 23 are elected by less than 80,000 of the electorate, and in the 2008 Legislative Council election 14 members were elected unopposed from these functional constituencies. the size of the electorates of some constituencies are less than 200. Only people who can demonstrate a connection to the sector are eligible to run in a functional constituency. The Legislative Council Bill 2012, if passed, amends the Legislative Council Ordinance to restrict the right to stand in Legislative Council by-elections in geographical constituencies and the District Council functional constituency. In addition to people who are mentally disabled, bankrupted, or imprisoned, members who resign their seats will not have the right to stand within 6 months' time from their resignation. The bill is currently passing through the committee stage. India. Universal suffrage for all adult citizens aged 21 or older was established under Art. 326 of the 1950 Constitution of India. The minimum age was reduced to 18 years by the Constitution Act, 1988, with effect from March 28, 1989. Japan. 1947, universal suffrage instituted with the establishment of post-war constitution. New Zealand. 1853, British government passes the New Zealand Constitution Act 1852, granting limited self-rule, including a bicameral parliament of the colony. The vote was limited to male British subjects aged 21 or over who owned or rented sufficient property, and were not imprisoned for a serious offence. Communally owned land was excluded from the property qualification, thus disenfranchising most Maori men. 1860. Franchise extended to holders of minors' licenses who met all voting qualifications except that of property. 1867, Maori seats established, giving Maori 4 reserved seats in the lower house. There was no property qualification. Thus Maori men gained universal suffrage before other New Zealanders. The number of seats did not reflect the size of the Maori population, but Maori men who met the property requirement for general electorates were able to vote in them or in the Maori electorates but not both. 1879, property requirement abolished. 1893, women won equal voting rights with men, making New Zealand the first nation in the world to allow adult women to vote. 1969, voting age lowered to 20. 1974, voting age lowered to 18. 1975, franchise extended to permanent residents of New Zealand, regardless of whether they have citizenship. 1996, number of Maori seats increased to reflect Maori population. 2010, prisoners imprisoned for 1 year or more denied voting rights while serving the sentence. Poland, 1918. In its first days of independence in 1918, after 123 years of partition, rights to vote were granted to both men and women. 8 women were elected to the Sejm in 1919. 58, 59, South Africa, 1910 The Union of South Africa is established by the South Africa Act 1909. The House of Assembly is elected by first past the post voting in single-member constituencies. The franchise qualifications are the same as those previously existing for elections of the legislatures of the colonies that comprise the Union. In the Transvaal and the Orange Free State the franchise is limited to white men. In Natal the franchise is limited to men meeting property and literacy qualifications. It was theoretically colour-blind but in practice nearly all non-white men were excluded. The traditional Cape qualified franchise of the Cape Province is limited to men meeting property and literacy qualifications and is colour-blind. Nonetheless 85% of voters are white. The rights of non-white voters in the Cape Province are protected by an entrenched clause in the South Africa Act requiring a 2/3 vote in a joint sitting of both Houses of Parliament. 1930 The Women's Enfranchisement Act, 1930 extends the right to vote to all white women over the age of 21. 1931 The Franchise Laws Amendment Act, 1931 removes the property and literacy qualifications for all white men over the age of 21, but they are retained for non-white voters. 1936 The Representation of Natives Act, 1936 removes black voters in the Cape Province from the common voters' roll and instead allows them to elect 3 native representative members to the House of Assembly. 4 senators are to be indirectly elected by chiefs and local authorities to represent black South Africans throughout the country. The act is passed with the necessary 2/3 majority in a joint sitting. 1951 the Separate Representation of Voters Act, 1951 is passed by Parliament by an ordinary majority in separate sittings. It purports to remove coloured voters in the Cape Province from the common voters' roll and instead allow them to elect 4 coloured representative members to the House of Assembly. 1952 and Harris v Minister of the Interior. The Separate Representation of Voters Act is annulled by the Appellate Division of the Supreme Court because it was not passed with the necessary 2/3 majority in a joint sitting. Parliament passes the High Court of Parliament Act, 1952, purporting to allow it to reverse this decision, but the Appellate Division annuls it as well. 1956 by packing the Senate and the Appellate Division, the government passes the South Africa Act Amendment Act, 1956, reversing the annulment of the Separate Representation of Voters Act and giving it the force of law. 1958 the Electoral Law Amendment Act, 1958 reduces the voting age for white voters from 21 to 18. 1959 the Promotion of Bantu Self-Government Act, 1959 repeals the Representation of Natives Act, removing all representation of black people in Parliament. 1968 the Separate Representation of Voters Amendment Act, 1968 repeals the Separate Representation of Voters Act, removing all representation of coloured people in Parliament. 1969 the first election of the Coloured Persons Representative Council, which has limited legislative powers, is held. Every coloured citizen over the age of 21 can vote for it, in first-past-the-post elections in single-member constituencies. 1978 the voting age for the CPSC is reduced from 21 to 18. 1981 the first election of the South African Indian Council, which has limited legislative powers, is held. Every Indian South African citizen over the age of 18 can vote for it, in first-past-the-post elections in single-member constituencies. 1984 the Constitution of 1983 establishes the tricameral parliament. 2 new Houses of Parliament are created, the House of Representatives to represent coloured citizens and the House of Delegates to represent Indian citizens. Every coloured and Indian citizen over the age of 18 can vote in elections for the relevant House. As with the House of Assembly, the members are elected by first-past-the-post voting in single-member constituencies. The CPRC and SAIC are abolished. 1994 with the end of apartheid, the interim constitution of 1993 abolishes the tricameral parliament and all racial discrimination in voting rights. A new National Assembly is created, and every South African citizen over the age of 18 has the right to vote for the Assembly. Elections of the Assembly are based on party list proportional representation. The right to vote is entrenched in the Bill of Rights. 1999 in August and another v Electoral Commission and others. The Constitutional Court rules that prisoners cannot be denied the right to vote without a law that explicitly does so. 2003 the Electoral Laws Amendment Act, 2003 purports to prohibit convicted prisoners from voting. 2004 and Minister of Home Affairs v NICRO and others. The Constitutional Court rules that prisoners cannot be denied the right to vote, and invalidates the laws that do so. 2009 in Richter v Minister for Home Affairs and others. The Constitutional Court rules that South African citizens outside the country cannot be denied the right to vote. United Kingdom. King Henry VI of England established in 1432 that only male owners of property worth at least 40 shillings, a significant sum, were entitled to vote in a county. Changes were made to the details of the system, but there was no major reform until the Reform Act 1832. It was not until 1918 that all men over 21, and wealthy women won the right to vote, and it was not until 1928 that all women over 21 won the right to vote. Suffrage in the United Kingdom was slowly changed over the course of the 19th and 20th centuries through the use of the Reform Acts and the Representation of the People Acts, culminating in universal suffrage, excluding children and convicted prisoners. Reform Act 1832, extended voting rights to adult males who rented propertied land of a certain value, so allowing 1 in 7 males in the UK voting rights. Reform Act 1867, extended the franchise to men in urban areas who met a property qualification, so increasing male suffrage to the United Kingdom. Representation of the People Act 1884, addressed imbalances between the boroughs and the countryside. This brought the voting population to 5,500,000, although 40% of males were still disenfranchised because of the property qualification. Between 1885 to 1918 moves were made by the suffrage movement to ensure votes for women. However, the duration of the First World War stopped this reform movement. See also the parliamentary franchise in the United Kingdom 1885 to 1918. Representation of the People Act 1918. The consequences of World War I persuaded the government to expand the right to vote, not only for the many men who fought in the war who were disenfranchised, but also for the women who helped in the factories and elsewhere as part of the war effort. All men aged 21 and over were given the right to vote. Property restrictions for voting were lifted for men. Votes were given to 40% of women, with property restrictions unlimited to those over 30 years old. This increased the electorate from 7.7 million to 21.4 million, with women making up 8.5 million of the electorate. 7% of the electorate had more than one vote. The first election with this system was the United Kingdom General Election, 1918, Representation of the People Act 1928. This made women's voting rights equal with men, with voting possible at 21 with no property restrictions. Representation of the People Act 1948. The act was passed to prevent plural voting. Representation of the People Act 1969. Extension of suffrage to those 18 and older. The Representation of the People Acts of 1983, 1985 and 2000 further modified voting. Electoral Administration Act 2006, modified the ways in which people were able to vote and reduced the age of standing at a public election from 21 to 18. United States. In the United States, suffrage is determined by the separate states, not federally. However, the right to vote is expressly mentioned in 5 amendments to the U.S. Constitution. These 5 amendments limit the basis on which the right to vote may be abridged or denied. 14th Amendment, regarding apportionment of representatives. 15th Amendment, the right of citizens of the United States to vote shall not be denied or abridged by United States or by any state on account of race, color, or previous condition of servitude. 19th Amendment, the right of citizens of the United States to vote shall not be denied or abridged by United States or by any state on account of sex. 23rd Amendment, provides that residents of the District of Columbia can vote for the President and Vice President. 24th Amendment, the right of citizens of the United States to vote in any primary or other election for President or Vice President, for electors for President or Vice President, or for Senator or Representative in Congress, shall not be denied or abridged by United States or any state by reason of failure to pay any poll tax or other tax. 26th Amendment, the right of citizens of the United States, who are 18 years of age or older, to vote shall not be denied or abridged by United States or by any state on account of age. Majority Muslim countries. See also, constituency, democracy, direct democracy, list of suffragists and suffragettes. The famous 5, timeline of women's suffrage, voting age, voting rights in the United States, women's suffrage organizations, women's suffrage publications, youth suffrage, secret ballot, references. Bibliography, Neil Atkinson, Adventures in Democracy, A History of the Vote in New Zealand. Alexander Keysar, The Right to Vote, The Contested History of Democracy in the United States. ISBN 0-465-02968-X, U.S. Commission on Civil Rights, Reports on Voting ISBN 978-0-8377-3103-2, Smallest State in the World, New York Times, June 19, 1896, p. 6, A History of the Vote in Canada, Chief Electoral Officer of Canada, 2007. External links. National Youth Rights Association, votes at 16 a campaign to lower the voting age in the UK, suffrage in Canada, vote sizing is different from the suffrage reform movements, in that each voter's political voice can be altered. Whereas vote counting usually maintains that each voter only gets one vote. Women's suffrage in Germany January 19, 1919 First suffrage for women in Germany